Good morning, everybody. Thanks for being here today. We're going to talk about the Texas 1-4 family residential contract. So, one of the big changes that has resulted from the NAR settlement is that compensation is not on MLS anymore, as we all know. And it really leaves it up to both parties to decide how a buyer's broker will get paid, whereas before it was just automatically coming from the seller's side. So now, if the seller or the seller's broker or both would like to offer compensation to the buyer's broker, they're going to need to fill out a compensation agreement. And that's what this is here. As a buyer's agent, you can fill it out ahead of time and have it ready to go so that when you submit a purchase contract, you will submit this with the purchase contract. And then as a listing agent, you can also have this filled out ahead of time if you and your client are going to be offering the buyer's agent compensation. You can have it filled out. And so anybody that comes with an offer, you're already ready to go with it. So we're going to go over that right now. In the first section, you're going to put the parties. So you're going to write the listing broker's name and information. And in the second section, you're going to write the cooperating broker's name and information. And of course, that can just be left blank. Whichever part can be left blank. If you're filling it out ahead of time, that's fine. The second part is the property. So you're going to write the full property address. Then we have the registration. You're going to write the name of the cooperating broker's client in the blank section. Number 4 is the term. So you're going to write the beginning and end dates of the agreement. Number 5 is the cooperating broker's fee. The listing broker will be paying the cooperating broker either a percent of the sales price or a set dollar amount. Enter the desired fee in one of the blanks. If a different option is chosen, you can write that in the third blank. Family members and assignees to the client will be bound to this contract. Number 6 is the entire agreement. So the agreement can only be changed in writing, and this agreement will supersede any previous agreements between the parties. And then in the last section, both brokers will sign and print. So we also have a buyer's rep agreement. One of the other big NAR changes is that all buyers have to sign a buyer's rep agreement with their real estate agent before they even go out to look at houses. Okay. So, the first thing you're going to do before you even get to a purchase contract is you're going to sign a buyer's rep agreement. And you're not going to turn in a purchase contract without the compensation agreement attached. So, first section of this contract is the parties. So the client's name and full information will go in the top section, and Dalton Wade Inc. will go in the second section, followed by the office address. Number 2 is appointment. So the client is naming the broker as their sole real estate agent. Number 3 is definitions. The term acquire will include purchasing or leasing property. Closing will mean the date title is conveyed to the purchaser of a property. Market area means the area in which the client is looking for property. Enter the market area in the blank below. Property means any real estate listed for sale. Number 4 is the term. Enter the beginning and end date for this agreement. Number 5 is the broker's obligations. The broker will use their best effort to help the client find a property within their market area and negotiate the purchase of the property. Number 6 is the client's obligations. The client will work solely with the broker in the search for a property to purchase in their market area. Number 7, broker compensation is fully negotiable and brokers independently determine their fees. Brokers are prohibited from receiving compensation for brokerage services from any source that exceeds the amount stated in this agreement. So this is another really big NAR change here that is the same regardless of which state you're in. That whatever is agreed upon between the buyer and the buyer's broker, if the seller or the seller's broker does decide to pay compensation, whatever they pay cannot be greater than whatever was agreed upon with the buyer. All right, A, we have the broker's fee. So enter either a percent of the purchase price or a flat fee. And then number 2, if the contract concerns a lease purchase, you'll enter that amount in the second blank. B, sources of compensation. The broker will first try to seek compensation from the seller or the seller's broker, and if they aren't offering compensation or if the payment falls through, the buyer will owe the broker this fee. The broker's compensation is earned when the client enters a contract to buy or lease within their market area. And if the client breaches the agreement, the broker will earn compensation for each property they find and enter contract with for the client. If the buyer finds a property listed with the broker, the cooperating broker's fee will be credited toward the buyer broker fee. If there is any other compensation being offered, you'll list that in E, number 3. We also have the protection period. So following the day this agreement ends, there will be a specific number of days in which the broker's right to a commission is protected. You'll write that number in the blank at number 7. The broker will send the client a list of properties they found for the client. And if any of those properties are purchased, the broker's compensation will be earned. This is negated if the client is bound by contract to another broker at the time of their purchase. G is escrow authorization. The client authorizes the broker to instruct an escrow agent to close a transaction related to this agreement. H, enter the county in which the broker will be paid. And 8 is representations. Every party to this agreement is certifying that they have the legal authority to enter into this contract, and the client asserts they are not party to any other brokerage agreement to purchase property. Number 9, intermediary. So you're going to check A or B. A, if the client wants to purchase a property listed with the broker, they are authorizing the broker to act as an intermediary under these circumstances. The broker will appoint an associate to work on the client's behalf. And B, the client does not want to purchase any properties listed with the broker. Number 10, competing clients. The client acknowledges that the broker can represent other possible buyers who might be interested in the same properties. Number 11, confidential information. The broker will keep the client's information confidential unless given consent or if required by law to disclose. The seller and their agent is not required to keep the existence of offers confidential. Number 12, mediation. The parties agree to negotiate in good faith and make all efforts to resolve any disputes that might arise. If that isn't possible, both parties will go to mediation and share in that cost. Number 13, default. If either party fails to comply with the agreement, the non-complying party will be at default. If the client is in default, the broker can terminate the contract and the client might be liable for the broker's compensation. The broker may also exercise any legal rights. Number 14 is attorney's fees. If there is a legal proceeding, the winning party can recover attorney's fees from the other party. Number 15, limitation of liability. The brokers are released of liability from loss or injury or damage to property, and the client will hold the broker and all of their associates harmless. And then number 16 is the addenda section. Choose the addenda that is needed for this transaction, if any, and make sure to include it with your paperwork and get the appropriate signatures. Number 17, you'll write any special provisions. And then number 18 are additional notices. The broker will not discriminate and will follow fair housing laws. The broker is not a property inspector of any kind, and the client should seek out experts when needed. The client should have an attorney study the property abstract and should also get a title policy. The client may purchase a residential service contract, and the client should be aware that they might be recorded or photographed while viewing properties. Clients should be aware of the dangers and possibilities of wire fraud and should always verify information before transferring money. And the broker cannot give legal advice. Please note this is a binding contract, and the client should consult an attorney if they need further understanding and clarification. And then we have the signatures. So we have a little bit of information here about if a client, someone who's a party to the contract is a trust or a corporation, this talks about who can sign. So it's just a handy little guide for you to reference back to. And then closing costs. So we have a table here that shows the most common closing costs in Texas, indicating, if they're paid by the buyer, the seller, or both. So also a handy chart for you. And then now we are in the pages of the contract. So in the first section, we have the parties. So you will place the seller's legal name on the first line and the buyer's legal name on the second line. The buyers or sellers could be an individual, an executor, an administrator, a corporation, an LLC, partnership, or trust. Number 2 is the property. Here, you'll provide the legal description of the property and every dwelling and attachment that is considered to be included. B is the improvements. So this paragraph explains that all permanent fixtures, attachments, and property improvements are automatically included in the sale, and it describes that the most common types of included items. Sometimes determining what's permanently installed is not that easy and often to be determined on a case-by-case basis. There is no rule of thumb theory set up. And so, a good example would be a built-in feature like benches, wood paneled library features, security alarms. It just really depends. A fixture is an item that was once personal property, like a microwave or built-in espresso bar, that has been attached in a certain way as to make it real property. Refrigerators are typically not deemed a fixture, but if it's a part of a custom kitchen, it's likely become a fixture and therefore should remain with the property. And then C, we have accessories. So this paragraph lists all the non-permanent attachments that will be included in the sale: shutters, blinds, curtains, etc. So just make sure the client understands that these items are considered accessories that will automatically be included unless otherwise listed as excluded. D, we have exclusions. So if there are any exclusions from the accessories or improvements list, that will go here. And then if there aren't any, you can just write none in the blank. And then exclusions only pertain to improvements and built-in items. So if the seller agrees to convey personal property, like a refrigerator, for example, it needs to be included in the contract to make it binding, and this can be accomplished using the non-realty items addendum to contract form. E is reservations. So any reservations, oil, gas, etc., should be made with an attached addendum. And the mineral rights addendum addresses the percentage the seller is willing to convey. And only a landman or an attorney should be used to determine the ownership of any of that type of property. Number 3 is going to be the sales price. So 3A is the cash portion of the loan that the buyer will bring to closing. This line can also be used if the buyer is paying all cash for the property. 3B is the amount the buyer is financing. So this line would not include closing costs, property taxes, or homeowner's insurance. So the loan amount may be larger based on the type of finance, loan term, or if the lender is going to roll in closing costs. 3C is the sales price for the property. And so an example would be the buyer's getting a conventional loan, 90% financed. The sales price is $100,000. And so sometimes it's easier to start with C and work your way backwards. So the first blank, you would put 10,000. The second blank, you'd put 90,000. And then in the third blank, you'd put 100,000. And then for the addenda type, when a buyer checks one of these boxes, they must remember to also check the correct addendum on paragraph 22. And then number 4 are leases. So unless disclosed here, the seller is not aware of any leases attached to the property. Once the contract starts, the seller cannot enter any new leases without the buyer's written consent. And then you'll check all types of leases that apply to this property in number 4, if any. Number 5 is earnest money and termination options. Earnest money is to show that the buyer has a serious intent, good faith to purchase the property. The funds are deposited into an escrow account within the time specified by the contract. In addition, these funds can be used in the event the buyer defaults as liquid damages to compensate the seller for such breach. If the seller is in default, the buyer is entitled to a return of their earnest money. Upon closing, the earnest money will be used to go towards closing costs or the down payment. Additional earnest monies may be taken to the title company if the parties require it under the paragraph. This section can be used if the buyer does not have the full deposit amount to deliver to the title company. An example could be that the buyer offers $2,000 in earnest money upon execution of the contract, then offers $1,000 within 10 days of payday. B is termination options. If the buyer fails to deliver the earnest money within the time required, the seller may terminate the contract or exercise seller's remedies under paragraph 15. The third part of this section here provides that the seller can consider it a default if the contract if the earnest monies is not delivered by the buyer within the stipulated time. If the seller chooses to terminate, they must use the seller's termination form. If the buyer delivers the earnest money after the 3 days and the seller does not exercise their right during this allotted time frame, the seller then waives their legal right to consider it a default. If the last day to deliver the earnest money falls on a weekend or legal holiday, the time to deliver the earnest money is extended until the end of the next business day. It's important, therefore, that you get a receipted copy of the contract reflecting the date the earnest money was tendered or received by the escrow agent. Title, policy, and survey, number 6. The seller will give the buyer you can choose one here, A title policy issued by, and then you'll list the company, in the amount of the sales price dated at or before closing, subject to some exceptions listed here. No later than 20 days after the title company receives this contract, the seller needs to send the buyer a commitment to title insurance, and at the buyer's expense, copies of restrictive covenants documents. The seller authorizes the company to deliver these documents. If they are not delivered in the specified time, the delivery time will extend to 15 days or 3 days before close, whichever is first. C is survey. So it must be done by a registered land surveyor and must be acceptable to the title company and the lender. You're going to check which box applies. Option 1, within blank days after the effective date, the seller will send the buyer and title company their existing survey. Option 2, within blank days after the effective date, the buyer will get a survey at the buyer's expense. Or option 3, within blank days after the effective date, the seller will get a new survey to the buyer at the seller's expense. D, objections. If the buyer can object in, so the buyer can object in writing to title issues disclosed on the survey other than items in 6A1 through 7, or if it prohibits the following property use or activities. You'll fill in the blank. If the buyer doesn't object within the allotted time, it will constitute a waiver of their objection rights. The seller will cure the buyer or lender's objections if submitted in time within 15 days of receiving them. The closing date can be extended if necessary, and it's noted that the seller is not obligated to pay for any objection fixes. If the objections are not cured within this period, within 5 days, the buyer can terminate the contract and get their earnest money back, waive the objections. And if the buyer doesn't terminate within this time frame, they will have waived their objections. E, title notices, abstract or title policy. The buyer is advised to consult an attorney to examine the abstract of the title on this property. This must be done within the buyer's right to object. Membership in property owners associations. So check which applies. The property is or is not subject to membership in a property ownership association. If the property is subject to mandatory association membership, the seller must let the buyer know. Governing documents are located in the real property records and can be obtained from the county clerk's office. Please note that any assessments to the property owners association must be paid, and failure to do so could result in a lien on the property. The property subject to mandatory membership in a property owners association addendum should be used if the buyer has any concerns. Number 3, statutory tax districts. If the property is located in a statutorily created district that provides water, sewer, drainage, or flood control services, the seller must deliver to the buyer statutory notices about the tax rate, bonded indebtedness, or standby fees to the district before this contract's close date. Tide waters. The appropriate addendum can be used if the property abuts tidal waters. Annexation. If the property is not in a municipality, the buyer must be aware that it may become a part of a municipality at a later date. To obtain a map of the extraterritorial jurisdictions of nearby municipalities, contact everybody in the general proximity to the property. And if the property is located in a certified service area of a utility service provider, there might be costs or charges that you'll be required to pay before you can receive water or sewer service. The buyer is advised to contact the utility service provider to determine if the property is in a certified area and whether there is a cost and waiting period for receiving services. If the property is in a public improvement district, the seller has to give the buyer written notice and must attach the appropriate addendum. And if the property has public transfer fee obligations, the seller must notify the buyer. If the property is located in a propane gas service area, the seller must give the buyer written notice and use the appropriate addendum. If the property adjoins a body of water with a storage capacity of at least 5,000 acre-feet, the seller must notify the buyer that the water level fluctuates as a result of lawful use of the water. And if there are any notices attached to this contract, you're going to list them on number 11, the bottom. And number 7, property conditions. The buyer, their agent, and their inspectors will be able to access the property at reasonable times. All inspectors must be licensed and permitted by law to make inspections. Hydrostatic testing must be authorized by the seller in writing. Seller's disclosure notice to 5.008 Texas Property Code. Okay, so you're going to check whichever applies. Either the buyer has received the notice or the buyer has not received the notice, and within blank days of the effective date, the seller will deliver notice to the buyer. If this doesn't happen, the buyer can determine the contract at any time, terminate the contract, and then get their earnest money back. And then the seller's disclosure of lead-based paint. This will be required for all buildings built before 1978. And then acceptance of property condition. The buyer's agreement to accept the property as is does not preclude the buyer from inspecting the property under paragraph 7A, from negotiating repairs, or from terminating the contract. So at the very top, you're going to check which box applies. Either the buyer accepts the property as is, or the buyer accepts the property as is, but the seller must make these repairs at their expense, and you can list those items there. Lender required repairs and treatments. Neither party is obligated to pay for lender required repairs unless otherwise agreed upon in writing. The buyer can terminate the contract and receive their earnest money back if both parties can't agree on who pays for the repairs. If the repairs exceed 5% of the sales price, the buyer can cancel this contract. The seller will complete the agreed upon repairs before closing, and they must be done by licensed technicians. The seller needs to give the buyer documented proof that the repairs were done, along with any warranties associated with the repairs. The buyer can extend the closing date by 5 days to offer the seller more time to complete the repairs if needed. If the buyer is concerned that environmental hazards will affect their ability to use their property as intended, they should attach the appropriate addendum to this contract. If the buyer decides to buy a residential service contract, the seller must reimburse the buyer at closing in an amount not exceeding blank. Number 8, brokers and sales agents. If a real estate agent is a party to this contract or is related to somebody who's a party to this contract, they must disclose this in writing before entering into the agreement. And you'll write that in the blank. Broker's fees. An agreement on brokerage fees is laid out in a separate written agreement. Number 9, closing. Fill in the closing date. At closing, tax statements, general warranty deed conveying property title will be delivered to the buyer. The buyer will pay the sales price in funds acceptable to escrow. The seller and the buyer will execute and deliver all applicable documents required for closing. Any liens or assessments will be paid from the sales proceeds. Private transfer fee must be paid to the seller unless agreed upon otherwise within this contract. Possession. Seller will deliver possession of the property to the buyer either at closing with funding or by a temporary residential lease form. When the seller delivers possession to the buyer, the seller will deliver written information about all smart devices, and terminate and remove all access and connection to those smart devices from their personal devices. Special stipulations. This section is to be used for informational items, which are statements that complete a blank in a contract form, disclose factual information, and provide instructions. Number 12, settlement and other expenses. So the following can be paid at or prior to closing. The seller's expenses, so releases by existing liens, including prepayment penalties, recording fees, release of seller's loan liabilities, etc., and the buyer's expenses, all expenses which are required by the lender listed here. Certain fees are not allowed to be paid by the buyer. Those are by the FHA program, the VA program, and other government loan program regulations. Number 13 is prorations. Current taxes, interest, rents, and regular periodic maintenance fees, assessments, and dues will be prorated through the closing date. The tax proration can be calculated by taking into consideration any changes in exemptions that will affect the current year's taxes. If the current year's taxes vary from the amount prorated at closing, both parties will adjust the prorations when the current year's tax statements are available. Casualty loss. If any part of the property is damaged by fire or any other casualty after the effective date, the seller must restore the property to its previous condition as soon as possible and before the closing date. If the seller doesn't comply due to factors outside of their control, the buyer can terminate the contract and get their earnest money back, or extend the time for performance up to 15 days, and the closing date will be extended. Number 15 is default. If the buyer doesn't comply with the terms of this contract, the buyer will be in default, and the seller can enforce performance or seek relief in accordance with laws, or terminate this contract and receive their money back. If the seller doesn't comply, and is in default, the buyer can enforce performance and seek other relief with accordance by law, or terminate this contract and receive their earnest money. Number 16 is mediation. Any dispute between the buyer and seller over this contract, which cannot be resolved through informal discussion, will be sent to mediation. If a dispute goes through a legal proceeding, the winning party will be entitled to recover all costs associated with the legal proceeding and any reasonable attorney's fees. Number 18, escrow. The escrow agent is a neutral third party to this contract and does not have liability for interest or earnest money, or for loss of earnest money caused by the financial institution controlling the deposit of the money. Earnest money can be applied to a cash down payment first, then to the buyer's expenses or any excess refunded funds. If termination occurs, if either party doesn't sign the release of earnest money, the escrow agent will deliver the demand from one side to the other. And if they don't receive a written objection from the other side within 15 days, the escrow agent can disperse the earnest money to the party demanding its release. Any party who refuses to sign a release that's acceptable to the escrow agent will be liable for damages. Notices sent by the escrow agent are effective once sent. Number 19, representations. The terms and conditions of this contract survive closing, and if any of the representations the seller made turn out to be false, the seller will be in default. Number 20, federal tax requirements. If the seller is a foreign person, the buyer will need to withhold from the sale proceeds an amount that complies with the tax law, and it needs to be sent to the IRS. And then the next two pages, or the last two pages, you'll write the property address, and then at number 21, you'll write the buyer and seller's contact information. Number 22, check all of the addendum that apply. Number 23, write the attorney's information. And then on the last page, you'll write the property address at the top and then write the effective date, and then both parties will sign. And then we just have the option fee receipts, if applicable, which I think probably most of them will be. And then the broker's information, all of the broker's detailed information will go on the next page. And that is all I have today for you guys. Thank you so much. I'm gonna stop recording and then we will go over any questions.